Hello, welcome to Listen and Score. The channel is to read for you, and this channel will help you in revising the concepts and preparing for examinations. With less effort, you can score more. This is second unit from the Administrative Law, third semester of LLB. Today we are going to read about Rule of Law, interpretation of Dicey's principle of rule of law. Meaning, rule of law is one of the important and foundation principles of the basic constitutional principles and the basic concept of administrative law. Rule of law is the supreme of the country. According to it, all are equal. Dicey says, every man, whatever be his rank or condition, is subject to the ordinary law of the realm and amenable to the jurisdiction of the ordinary tribunals. Augusta legibus soluta non est. The wife of the emperor is not exempted from the laws, is the famous legal maxim in England, which upholds the prominence of rule of law. According to this legal maxim, all are equal before the law, irrespective of their ranks, status, money, etc. Quod ad jus naturale attinet omnes homines equalis sunt. All men are equal as far as the natural law is concerned. It is another legal maxim showing the importance to the rule of law and equality before the law. Dicey's rule of law has been adopted in the Constitution of India in Article 14, equality before the law. The state shall not deny to any person equality before the law or the equal protection of the laws within the territory of India. Interpretation of Dicey's principle. Albert Van Dicey, 4th February 1835 to 7th April 1922, was a British jurist. He wrote the Law of Constitution in 1885. He laid down the doctrine of rule of law. According to him, the rule of law has parts. Number 1, absolute supremacy of law. Absolute supremacy or predominance of regular law is the first principle enunciated by Dicey. According to this principle, king, his employees, that is government, and its employees are below the law. The law of the land is the supreme over all. He asserted Englishmen were ruled by law and law alone. Wade in his administrative law also supports Dicey's views. Wade remarks, the rule of law requires that the government should subject to the law rather than the law subject to the government. Second one, equality before the law. Equality before the law is the second principle of Dicey's theory or rule of law. According to this principle, all men are equal. The Secretary of State to clerk and all other citizens are equal before the law. No one can be degraded. No one can be upgraded. Law gives equal justice to all. No discrimination among poor and rich, the official or private citizens. In France, there have been two sets of courts. One is civil court. These civil courts solve the problems and matters between the private persons. Second one, administrative tribunals. These administrative tribunals or courts solve the problems and matters between the private persons and the government or its employees. It is known as Diet Administrative. In Britain, there was no such type of discrimination. Dicey hated the system of Diet Administrative. He upheld the Britain's administration where judicial review and precedents have played an important role in the administration. In England, all persons, whether they government officials or private persons, are treated alike and are subjected to judicial control and review. Third one, predominance of legal spirit. The third principle is predominance of legal spirit. Dicey appreciates the predominance of legal spirit prevailing in Britain. There are two types of constitutions in the world. One is written and the second one is unwritten. Britain has unwritten constitution. It is dependent upon conventions, customs and judicial decisions. All of them have legal spirit. It has been proved that the unwritten constitution of Britain is better than written constitution of some of the countries. It is generally presumed that the written constitution is the source of legal rights, liberties of citizens. This general presumption is not true in the case of Britain. Legal spirit is the real source of law in England. This legal spirit of Britain is seen in its customs, conventions, judicial decisions. Dicey opines that the individual rights and liberties are more safely protected in Britain than in France. Arbitrary powers, fourth one. Lord Action says, every power tends to corrupt and absolute power tends to corrupt absolutely. Dicey says, wherever there is discretion, there is room for arbitrariness, and that in a republic no less than under a monarchy, discretionary authority on the part of the government must mean insecurity for legal freedom on the part of its subjects. This is the view of Dicey. According to him, the rule of law does not give scope to absolute and arbitrary powers to the executive. There could not be any special privileges for a government official or any other person. Several jurisprudents analyzed and gave the meanings of the term rule of law. According to their views, Davis, in his book Administrative Law, published in 1959, gives 7 principal meanings of rule of law. They are: number 1, law and order. Number 2, elimination of discretion. Number 3, due process of law of fairness. Number 4, natural law or observance of the principles of natural justice. Number 5, preference for judges and ordinary courts of law to executive authorities and administrative tribunals. And number 6, judicial review of administrative actions. This is the most modern concept of the doctrine of rule of law. Griffith jurisprudent gives 5 principal meanings of rule of law. They are: number 1, elimination of discretionary and arbitrary powers from executive. Second one, judicial review. Third one, natural law and observance of the principles of natural justice. Number 4, equality before law. And number 5, supremacy of law. Griffith further says, 5 meanings of rule of law have been suggested. Of these five meanings, only the last two have legal significance. This is not to say that the others are without influence, but their influence lies in the realm of politics. Merits of the doctrine of rule of law. The doctrine rule of law is an effective controlling instrument over the executives. It keeps the administrative authorities within their sphere. Number two, this doctrine honors the conventions and the customs of the country. Number three, it also recognizes the judicial legislation as a part of rule of law. It gives freedom to the judiciary to control the executive who exceed their jurisdiction and powers. Wade stresses that the British Constitution, even though it is unwritten, is founded on this principle. Number four, not only in Britain, but also in USA, Australia, India, etc., that is, in almost all Commonwealth countries, this doctrine prevails. Number five, Magna Carta says, no free man shall be taken or imprisoned or disseised or outlawed or exiled or in any way ruined, nor will go or send for him, except by the lawful judgment of his peers or by the law of the land. Sixth one, they says prima facie in tension with the conception of the rule of law as simply a structure of clear rules, reliably and fairly enforced without regard to their substantive content, the rule book conception, and with the ideal rule by an accurate public conception of individual rights, the rights conception. Number seven, protection of human rights. Basically, rule of law is aimed to protect the human rights, bodily integrity, privacy, personality from the executive. Number eight, principle of rationality. Rule of law imposes pressure on the decision makers, especially political and legal structure, to give reasons for their decisions which must possess rationality. Number 9, transparency, reason giving, etc. Rule of law requires the public servants to strictly adhere to transparency, reason giving, participation requirements, legal accountability, and liability. So there are almost 9 to 10 merits of the doctrine of rule of law as I have read till now. Now let's go to the criticism or demerits of doctrine of rule of law. To the listeners, again a reminder that we are reading out the content only from the materials and the books and the information which is available with us. You please cross check with the knowledge that you already have as well as with the information available with you. Hope this is helping you in recollecting the points, right? And this surely will make you score more with less effort. Please do subscribe and share with your friends. Now, criticism or demerits of the doctrine of law. There is a widespread disenchantment in the Dicey's rule of law. Several jurisprudents attacked this doctrine. Some of the important criticisms are as follows. Number 1, this doctrine fails to distinguish the distinction between arbitrary power from discretionary power. Arbitrary power is inconsistent with rule of law. But always discretionary power cannot be discarded from the executive. Even the courts also enjoy discretionary power while disposing the proceedings. The discretionary power should not be attacked by this doctrine. Of course, too much severe discretionary power may be subjected to control. Number two, Dicey's concept of rule of law was not accepted in Britain during his period itself. In fact, it was evident that administrative law and administrative authorities were in existent during his period. Number three, Dicey strongly opposed the French droit administratif. In fact, the rule of law and the mere court review could not effectively control the activities and maladministration of the executive. At the same time, the droit administratif achieved the good results in controlling the executives. After the incident of Crichel Down Affair 1954, a great effect and development has been seen in the administrative law in England. The courts have played a very dynamic, creative, and constructive role. The administrative law, especially from 1963, took the divergent progress in England. Once the administrative law was described as a continental jargon, but it is now accepted that England has a developed system of administrative law. Number 5, J.D.B. Mitchell has made a radical suggestion to import the system of droit administratif and conceal de edat in England in place of Dicey's strict theory rule of law. Number 6, some of the jurisprudents point out that Dicey criticized priority to king and his officials and brought them under the law. But at the same time, he forgot that England king or queen has most privileges. Even now such privileges are continuing. These privileges were existent in his days too. Number 7, he did not give priority to the administrative tribunals, which are the best media to control the maladministration of executives. At the same time, he forgot to recognize the existence of such administrative tribunals in England during his life period. Lord Hayward wrote The New Despotism in 1929, in which he strongly criticized the bureaucracy, expansion of administrative powers, excess delegation of legislative powers to the executive, failure of rule of law over administrators, etc. Number 9, the Committee on Ministers' Powers, the Donoughmore Committee, were appointed in 1929 to consider the powers exercised by or under the direction of or by persons or bodies appointed specially by ministers of the crown by way of delegated legislation and judicial or quasi-judicial decisions, and to report what safeguards would be desirable or necessary to secure the constitutional principles of the sovereignty of the Parliament and the supremacy of the law. And this is all about the Dicey's principle, that is the rule of law as propounded by A.V. Dicey. We have seen merits as well as the demerits of the law, and this may be like for 15 or 20 mark question. This can give an appropriate answer to a 15 or 20 mark question. Right, this is all for now, and please do subscribe and share with your friends. And if any suggestions are there, please comment. Thank you.